I'd like to say a warm hello to the participants of the 50th meeting of the Task Force on Access to Justice, and I would like to express my thanks and gratitude to Justice Luc Lavrison and to Marina Janusz from the Aarhus Secretariat, the Environmental Affairs Division, for kindly extending this invitation to me. It's a great honor to be invited to speak at the meeting, although I do apologize for not being able to be there in person. My name is Christina Voigt. I'm the chair of the IUCN World Commission on Environmental Law, and I'm a professor of law at the University of Oslo. And today I will be speaking about access to justice in the context of climate change and the turn to international courts. I will briefly talk about 3 reasons why we currently see a very interesting phenomena, which is that climate litigation, climate change cases have made their way to supra-regional and international courts. And the 3 reasons are, first of all, the absence of specific courts. That's one of the reasons why we see a turn to human rights treaty bodies. The second one is the absence of success. We have for many years now seen a wave of domestic climate litigation, but in several cases, the applicants were not successful and now are turning to supranational and international courts. And finally, the third reason that I'd like to briefly highlight is the absence of legal clarity. In order to get clarity on the obligations of states, we see currently a very strong push for requests for advisory opinions from international judicial organs. I will provide a couple of examples for each one of these 3 reasons, and in the end, provide some brief reflections. Let's start with the first one, the absence of courts, and as a reason for why we see individuals turning to international human rights treaty bodies in order to seek access to justice. We know that the treaty bodies of the United Nations human rights treaties have the competence to hear claims of violations of relevant UN human rights treaties. And that is often the case in the absence of legal protection through domestic courts, or, of course, after the exhaustion of domestic remedies where the applicants have gone through the domestic judicial system without being successful in having their case heard and decided in their favor. There is no special international human rights courts other than the regional human rights courts in the Inter-American system on human rights, the European system, and the African system. But within the international system, we have the UN human rights treaty bodies who in the recent years have been increasingly engaged in climate change related claims. I will briefly mention 3 examples of where and when UN human rights treaty bodies have issued decisions or views on human rights and climate change related intersections. One of the first ones were the decision by the United Nations Human Rights Committee in 2019 on a case brought by an individual from Kiribati, Mr. Taitiota, against New Zealand. Mr. Taitiota claimed to have the status of legal migrant to New Zealand, according to New Zealand law and international law, due to the conditions of his homeland. His homeland is Kiribati in the South Pacific Ocean, and he claimed that due to climate change impacts, he had left his home country together with his family and settled to New Zealand, where he then deserves to be recognized as a legal migrant according to New Zealand law. This case was, the claimant lost on the merits. It's too far-reaching to go into this, into the reasons here. But the importance why this case has received international attention is that the UN Human Rights Committee, in its decision, actually opened the door to recognizing climate refugees, people that move or cross international boundaries due to the impacts of climate change. Until this case was decided, this was a very controversial issue in international law. We know that the 1951 Refugee Convention's categories do not capture directly or even indirectly climate refugees, and the requirement of persecution is also a very difficult requirement when it comes to climate refugees. However, there is a customary principle of non-refoulement, meaning that an individual who has to fear for his life or her freedom in a particular country is not supposed to be returned to that country. And the United Nations Human Rights Committee in that particular case decided that in the context of climate impacts, that customary principle of non-refoulement could be applicable. It stated that without robust national and international efforts, the effects of climate change in sending states may trigger the non-refoulement obligations of receiving states. This is a very important element, a legal development through to human rights treaty bodies. Although this decision is, of course, not legally binding, it is something that provides a legal argument which may or may not be further developed and used by other international courts. Another very important decision, also by a UN treaty body, was in a case called Saatchi and al. Versus 5 countries, versus Brazil, Argentina, France, Germany, and Turkey. That decision was issued in 2021. It was a case brought by 16 children who claimed that those 5 countries, by not taking sufficient action to address climate change, were violated in their rights under the United Nations Convention on the Rights of the Child. Now, again, this case was considered not to be admissible because those children did not exhaust the national remedies in their respective countries. They came from a wide variety of different countries. But importantly, the UN Commission on the Rights of the Child, the relevant treaty body under the United Nations Convention on the Rights of the Child, found that states do have the obligation to protect the rights of children under the United Nations Convention on the Rights of the Child against the impacts of climate change through ambitious action on climate change mitigation and adaptation. And very importantly, it also found that the protection of children's rights under the convention applies worldwide in and outside the territory of the respective states. So extended the protection of children extraterritorially in the context of the convention. And the third example that I'd like to mention here is a fairly recent one from September last year, issued again by the United Nations Human Rights Committee. This time it concerned a group of an indigenous minority individuals from the Torres Strait Islanders. These are Australian citizens who brought a case against the Australian government, claiming that due to sea level rise, their rights under the International Covenant on Civil and Political Rights, in particular rights to life, to private life and indigenous culture, were violated. And here, for the first time ever, the United Human Rights Committee held with the claimants and in its views stated that Australia violated the human rights of those citizens, of its citizens of belonging to an indigenous minority, due to not having taken timely and adequate adaptation measures, in particular building seawalls to protect the encroachment of the ocean, which would lead to violation of rights to life, private life, and indigenous culture. Very important finding. It's the first official statement that we have by a United Nations Human Rights Treaty body on the direct link between states' inaction or insufficient action here on adaptation and a violation of human rights. I have written a little bit about this case. If you're interested, here is a link blog that was published right after the decision came from the Human Rights Committee. Now, the second element for why we're seeing a turn to international courts and access to justice in climate change is the absence of success in domestic litigation. As I already mentioned, and as all other speakers have been talking to, we see this worldwide wave of climate litigation where citizens or non-governmental institutions take governments and companies, private actors to court with regard to various climate change issues. In many cases, or in some cases, the claimants are successful. In some cases, they are not successful, and then have the possibility to bring the issues, if they concern human rights violations, to supranational, to regional courts. One requirement here is, of course, the exertion of national remedies, but we'll see how, for example, the European Court on Human Rights will treat that requirement, because it has, in particular, one case pending, Agostinho versus Portugal, and 32 other member states of the Council of Europe. Here we have several young citizens of Portugal claiming that basically all the member states of the European Council of Europe have not reduced their greenhouse gas emissions to the extent necessary, and thereby violate those young adults' rights to life and private life. So we see now cases coming up before the European Court on Human Rights, but also in the Inter-American Court on Human Rights. And the general claim seems to be that states have not taken all appropriate and necessary measures, have not fulfilled their positive legal obligations under human rights law to protect those rights against the impacts of climate change. And again, briefly, some examples here. As you perhaps all have heard, the European Court on Human Rights held its first two hearings just a couple of days ago on Wednesday last week in the case of Swiss senior women against Switzerland, and the second case of a city and citizens in France against the government of France. In both cases, again, dealing with insufficient climate mitigation action by Switzerland and France, respectively, and thereby violating human rights of the claimants, in particular, right to life and private life. And these cases have gone through the domestic legal systems, and the claimants were not successful there. The third case that is pending, which will be heard later this year, is the one that I just mentioned, where we have a number of Portuguese children and young adults claiming that all members of the Council of Europe have violated those children's rights by not reducing greenhouse gas emissions to the extent necessary. And here, of course, the question, many questions are open with regard, for example, to the extraterritorial application of the European Convention on Human Rights, as well as the requirement of exhaustion of national remedies, because the claimants in that particular case, Duarte Agostinho, did not exhaust any national remedies, but went straight to the court in Strasbourg. And if that wasn't enough, there are another 6 cases that are also brought to the European Court on Human Rights, but they are currently adjourned. And the third and last element that I wanted to mention is the absence of legal clarity that is now being the reason why we see a turn to the international judiciary. We do know that international law develops through negotiations and treaty making, but also through the establishment of customary law, but also through the jurisprudence of international courts, in particular where we have certainty about what exactly is the content of a legal norm or rule. And when it comes to climate change, there are a number of gray areas in international law where we don't really have any authoritative statement, any exact answers of what exactly for example, the legal obligations of states are to protect the climate system. The Paris Agreement and the Framework Convention on Climate Change give some indication, but not in terms of concrete, substantive legal obligations of what exactly each state has to do to protect the climate system, and whether this obligation is differentiated between different groups of states, developed and developing countries, for example. Also, what are the consequences of a violation of that obligation should it exist? And in particular, what are the obligations in a temporal scale, towards current generations, but also in particular towards future generations? What exactly does human rights law require of states to protect the human rights of their citizens and citizens in other places of the world against the impacts of climate change? Or another area of significant uncertainty is what exactly does the law of the sea, the United Nations Conventional Law of the Sea, require of states to address climate change in order to protect the marine environment? So these are several areas of gray these are gray areas where conclusive legal statements are absent. And for those reasons, we see currently a push for several advisory opinions from different international courts and tribunals. And again, I'll give you some examples. The first one is a request for an advisory opinion from the International Tribunal for the Law of the Sea, ITLAS, which is based in Hamburg. This request was brought last year in November by COSIS, which is the Commission of Small Island States on Climate Change and International Law, which was established in 2021 and currently consists of Palau, Barbuda, and Tuvalu, 3 small island developing states. And they put the following question to the International Tribunal on the Law of the Sea: what are the specific obligations of state parties to UNCLOS? First, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effects that result or are likely result from climate change, including through ocean warming and sea level rise and ocean acidification, which are caused by human-made greenhouse gas emissions into the atmosphere. And the second question is, what are these specific obligations to protect and preserve the marine environment in relation to climate change impacts? And here, as I said earlier, these are questions that have not, or these obligations that have not exactly been carved out. They have to be interpreted, or the convention has to be interpreted in the context of climate change. And this is what the request seeks ITLAS to do. The second request for an advisory opinion with regard to clarification on obligations of states with regard to climate change is a request to the Inter-American Court on Human Rights, which came in January this year by 2 states, Colombia and Chile, together. And they put a long list of 20 questions to the Inter-American Court on Human Rights, who is based in San Jose in Costa Rica. I didn't list all these questions, but they deal with various aspects of the American Convention on Human Rights and its interpretation in the context of climate change. And the newest request for an advisory opinion, again, came last Wednesday by a resolution of the United Nations General Assembly, which was adopted by consensus and was based by an initiative of law students from the Pacific, and was then taken up by the government of Vanuatu, and it finally supported by more than 120 co-sponsoring states. And that request goes to the International Court of Justice to issue an advisory opinion on these questions. First of all, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases and for present and future generations? And the second question goes on, once these obligations are specified, what are the legal consequences under these obligations for states where, when by acting or omitting, they have caused significant harm in the climate system, in particular with respect to small island developing states, which are particularly vulnerable to climate change while having done the least to cause that problem, and also to peoples and individuals of the present and future generations affected by climate change. So these are pertinent, open questions which need some sort of clarification, an authoritative statement, and here this statement is sought by the International Court of Justice. I would like to wrap up by offering some reflections. The first of that is that access to justice through climate litigation at the international level is something that is going to stay with us. It has reached the international level, and I think that push to have international apex courts giving either or deciding either contentious cases or giving advisory opinions is something that is just a logical continuation of the domestic cases that we've seen for several years already. Access to justice, as I already mentioned, leads to taking climate cases to the highest courts internationally, in particular in cases where the claim was either unsuccessful in domestic courts or where the law is unclear. However, it is also unclear what exactly international courts will or what they can say in, for example, rendering those advisory opinions. For example, the International Court of Justice historically is perhaps not the most progressive court. It's fairly conventional in its approach to international law, and we will have to see what kind of advisory opinion it may render. The same with the European Court on Human Rights. It has never decided a case with which dealt with climate change. So the hearings last week were historical. It was the first time ever that climate change related issues came to the European Court on Human Rights. Now, the advisory opinion requests that we are seeing currently may build up to contentious cases later once the law has been clarified. So that's definitely a place to watch. But there's also questions of how the decisions and advisory opinions by international courts actually relate to international negotiations, not legally, not in a legal sense, but we all know that climate change is a global problem, and there's a need for constructive multilateral solutions, which may not be fast enough. But how do advisory opinions by courts relate or play into these international negotiations, and vice versa, are very interesting and pertinent questions to answer, and whether they can be supportive or potentially disruptive to multilateral negotiations is something that will need to be seen. I will stop at this moment, and I thank you all very much for your attention.